Okay, well, we're getting started. It looks like we're missing a few people. This video is actually kind of ties two subjects that we'll be talking about this week. One is uh, legal aspects of our business, and the other one that I plan to cover on Friday will be some of the technical, um, some new strategies, I guess you could say, in doing our work. And this video kind of covered both. On the one hand, the big subject they were talking about was there was a murder trial going on. They had lots and lots of interest, and they were able to tweet information out of it. In most courtrooms, they don't allow cameras, and they don't allow, especially video, big, or video cameras, almost never, and even handheld cameras or taking pictures with your mobile. They typically don't allow that in America, and I doubt they do in most other countries. And so, but by just tweeting information out, it was helping to create kind of at least a word picture of what was going on and a sense of immediacy that, as they were saying, is rare to find in courtroom journalism. Um, and so, like I say, there's legal aspects to it. The fact that it is sometimes challenging to do your reporting if you're reporting out of a courtroom, but the some of the advantages of Twitter, not only in that situation, but he's also talking about the one saying he uses Twitter or Facebook on almost every story because what he's doing, he's looking for sources, and so finding people that have some, if you have a pretty good following, finding people that have a perspective on a story can be valuable. And so he finds it, more valuable than most other electronic tools uh, in finding sources, in finding story ideas. They mentioned getting feedback from their followers. So if they didn't explain something very well, they can correct it or increase uh, their reporting on a certain subject that their readers or listeners don't think is adequate, uh, and creating that sense of uh, relationship between the listeners and the reporters, the audience and the reporters, which can be extremely valuable and used in many different ways. So again, I'm mostly doing it because I decided I'd go ahead and use the beginning of our class where most people weren't here yet. I just turn on the video. But I'm going to proceed now and talk a little bit more about legalities and ethics and propriety in journalism, which was in um, our syllabus or whatever, one of our documents. Anyways, what we're going to cover this week, among other things. So reporters and editors they need to have a pretty good knowledge of what's legal, what's not legal. And it's going to vary from country to country. Even in America, it varies from state to state. For example, I may have told you, I don't remember, but many years ago, I was editor and publisher of a group of weekly newspapers, and there was um, an incident where maybe I didn't tell you, I don't remember. Anyway, there's an incident where our community became the focus of the top investigative journalism news program in the country called 60 Minutes. And they reported in such a way that I was sure that they were wrong, despite their reputation and many awards. So I began investigating closer up as to what was going on. And I won't go into the details of the story. It takes too long, kind of complicated. But one of the people involved was, in a peripheral way, was the owner of the biggest local bank. I don't know if he's the sole owner but anyway, he was the CEO, and I think he was the primary owner of it. And so he was a very proud man, very high standing in his church and in the community and so forth. And anyway, somebody told me that when he was going to serve some papers to foreclose on some property that a man owned, that as he got out of the car and walked towards the house to serve these papers, these legal papers, his car blew up behind him. Now, this is actually the person that told me this was the brother-in-law of the person who would be suspected in blowing up the car. But his brother-in-law thought the guy was crazy. Anyway, it got very complicated, and I called up the bank president, and and this was just one, relatively, even though it sounds pretty interesting, it was actually a relatively small part of the story. But I did feel like if in order to include that part of the story at all, I had to ask the bank president about it. And so I called him up, and anticipating that he might hang up on me, I put it on a recording device. And so I asked him about this incident and what happened, and he fairly quickly said that he wouldn't comment it and hung up on me. And so the story came out, and because I did include that part of the story, I was obliged as a journalist to let my readers know that I did ask the bank president about it, and he declined to comment. And that's all I said about it. Well, after the story came out, he came in and he was very upset because actually he could have been a very positive part of the story, and instead of by hanging up on me, he kind of made it a little bit negative, unnecessarily. And so he literally backed me up in the corner. He was a little guy. He was only like this tall, but he was. I don't know if you know very many Germans. Actually, our German professor is one of the nicest guys I've ever known. But they can be a little bit. Several of the German. By the way, I'm half German, so Germans can be a little bit hard exterior, and they can be a little bit abrupt and so forth. In my experience with them. And so this little German guy backed me up in the corner, started pounding my chest and yelling at me about not giving him a chance to answer, to answer the story. And he was like, he backed me in the corner and pounded in my chest, and I finally had to push him away and say, "Look, I don't care who you are, you're not going to treat me like this." And by the way, I did give you plenty of opportunity to comment on the story, and you refused to hang up on me. And his response was, "No, you didn't give me a chance. You didn't give me a chance." And I said, "Well," and this is probably a mistake. I said, "Well, I recorded it." And so then he demanded to hear the recording. So I played it, and it was actually more clear than he was even more rude than I thought he was. And I gave him more of a chance than I recalled having a chance to give him to respond. And so he was still mad. He went out and tried to get me arrested for wiretapping. Now, that's just one legal. It does not covered by most textbooks. But as I've told you in the past that there are times when it's important to me to have a good, have evidence. And so I record a lot of stuff. In this case, it wasn't so much that I was trying to entrap him or anything like that, or I anticipated he'd hang up, and I thought he might give me one or two sentences, which he did, by the way. I don't remember exactly what he said, but he gave me about 2 or 3 sentences before he hung up. And so I had those words, and I didn't, I could talk to him without having to try to write down the notes and stuff at the time. So for note taking, it was good. But you do need to know whether what I did was wiretapping or not. I could have gone to prison for that, except in that particular state, it was not. And like I say, in America, every state has their own laws on wiretapping. I don't know that I knew whether or not that was against the law. I don't remember now. That's many decades ago now. Um, but it should be important to you to know um, many aspects of the law, including that one, especially if you're going to do any recording over the phone. Would this be wiretapping? Now, in that state, it was not. As long as one person, one of the two people on the phone call knew that it was being recorded, it was not wiretapping that the other person did not know. But there are states in America where it would be considered wiretapping, that both sides had to know that it was being recorded. Um, so it's important. We're mostly going to talk about things like libel and invasion of privacy and things like that today. And those are the things that most textbooks talk about. But you should become aware of other laws, such as wiretapping, if you're going to be recording anything that somebody else may not be aware of. Now, sometimes I record stuff even in states where it's supposedly illegal because I know I'm never going to tell them that it was recorded. It was only for note-taking purposes. And so I was not, certainly was not trying to do anything to them. I was trying to make sure I got the quotes right. And so as long as they don't know, it's not going to hurt them, right? But if you're ever going to tell anybody, then you better know whether you're doing it legally. This mentions here in America, there's no requirement at all to have a license if you're in the print media. If you have a newspaper, you can start up and you can go to work tomorrow, and you don't have to do anything. With broadcasting, we do have licensing, and that was created in the 1920s when a whole lot of people started opening their own radio stations, and they were conflicting with each other. And so if you were, say, one was in one city and one was in another city, and you were living right in between them on that frequency, you'd be hearing both stations at the same time, which means you really heard neither one at the same time. I mean, it's just a mess. And so the government decided that it was a public utility, that airwaves, by their very nature, were limited, and that it had to be considered a public utility, and therefore they had to license broadcasting, despite the First Amendment, which says that that the government will have no control over journalistic efforts. But because of the nature of broadcasting, they did exert that control, and the Supreme Court agreed that that was necessary. Other countries, of course, may require licenses to be a journalist. And even in the United States, there are advantages. In some states will give you advantages if you register as a journalist. And in fact, there's an argument over things like, is a blogger a journalist? In some states, a journalist is given the right to protect their sources. And then a blogger was taken to court because he would not reveal his sources. He considered himself a journalist, and where it wasn't a profession, he wasn't making any money at it. The question is a blogger a journalist? Would he be covered? Would he, by that law, be given the right to protect his sources? And I think at that point they had not settled that question. And again, even in America, it depends state by state. Some states give no protection to journalists to protect their sources at all, and some do. And there's this loose end. Do bloggers count? What do you have to do to be a journalist? And obviously, if they have some sort of a registration process, that would answer that. But in this case, like I said, the blogger had information of a crime that he only knew by promising somebody not to reveal the source's name, and so he ended up going to jail for not revealing it. Now, in other states, any journalist can go to jail if they, again, this is not covered in the PowerPoint, but if a journalist in this very same situation, if a journalist in America has knowledge of a crime and he's required to come to court, and the judge promises him immunity, you will not be charged with any crime here. Therefore, you have to testify. We see, so now the Fifth Amendment of the American Constitution is that you can't incriminate yourself. But there's really nothing that covers this issue of protecting a source. There's nothing in the Constitution that guarantees protecting a source. So in many, if not most states, I think most states in America still do not protect a journalist's sources. And so if the judge says you're given immunity, you have to testify, and you refuse to, then they can put you in jail until you agree to. So you can actually be in jail for years. And I think there have been, there's one I'm trying to remember a long time ago that was in jail at least for many months, if not over a year, for refusing to give up her sources. And indeed, that's one of the questions. When you agree to anonymity, which we'll also talk about probably a little bit on Friday, when you agree to anonymity, are you willing to go to jail for it? You know, what is the subject? Is it a subject serious enough that you might go to jail for protecting your source? And how important is your credibility? If you promise somebody that you will not reveal their name, and then you get in this situation, you're in front of a judge, and the judge says you will reveal that name, and you say no, and you're going to jail, will you do that? Are you willing to go to jail for that source? So when you start thinking about anonymity, now again, every country is going to be a little different. And in the United States, every state is different in this regard. You need to know the law, and you need to remember that you're making a very serious decision when you give somebody anonymity. Now, if it happens to be a subject that you don't see any possible way that it's going to end up in court, then of course you don't worry too much about it. But then, are you sure? It's hard to know sometimes what could end up in court. For example, just some of the stuff going on right now. Trump has not pursued it. Ironically, you know, the liberal press loves Obama and hates Trump, but Obama put more people in prison for revealing classified information than all the other presidents in history. He's not seen that way. And Trump has gone just the other way. He's released people from prison for having gotten caught, for having, you know, like there was a submarine sailor in the U.S. Navy that took a picture of himself in a nuclear sub. He was sent to prison for that because that was classified. Nuclear subs are classified. And so he sent it to his parents. Nonetheless, he was in prison for quite a while until President Trump let him out and said, this is, you know, you've been there long enough, basically. So you can go to prison for something that seems pretty innocuous when it comes to things like classified information. And yet, so Trump hasn't gone after anybody, and yet there's a record number of people that are revealing classified information from the U.S. government to try to get him impeached. There's never been anything like it. Many stories have been based on anonymous sources. If he wanted to, he could actually haul every one of those reporters into court and demand to know their sources and put them in jail if they didn't do it. But he's not doing that. Obama might have. Obama wiretapped journalists. He did lots of stuff that somehow the liberal press doesn't seem to care that it was because they loved him and they hate Trump. So anyway, some things just to think about. The law is very, very important part of your work as a journalist. And I'll talk a little bit more some of my other experiences with that. This is the American perspective, so I can go rush through some of this pretty quickly because I don't know whether it's true in Malaysia. I don't know whether it's true in China. I don't know whether it's true in Uzbekistan. I don't know what's true in some of these different countries. But in America, media are not considered public utilities. They can accept or reject any story, any advertisement, any picture, any letter. Of course, they take some responsibility for that too when it comes to things like libel and invasion of privacy. if those are laws. That also is very different um, in different countries. One of the main differences between what we consider, the Western democracies and other countries that call themselves democracies in many cases, is that among the Western democracies, things like invasion of privacy and libel are not criminal laws. They're not. You don't get sent to prison for those things. Um, you get sued. And so somebody, if you've invaded their privacy or if you have uh, libeled them, you said bad things about them, and you didn't, and it got printed. Not only is the journalist or the newspaper or the broadcast in danger of being sued for having quoted you, but you as an individual, whatever you are, whether you're a reporter or not a reporter, are in danger of libel or slanders. Slander is basically spoken word, libel is a printed word. Same thing, otherwise. So um, in many countries that are not well-developed democracies, they use the criminal nature of libel and slander and invasion of privacy as a way to control journalists. Because journalists are afraid to be sent to prison for something, and they also force you to prove that what you said was true and so forth, and they may not give you much of a chance to do that. So they end up using these laws to control the press, which doesn't happen in America. You can, the press can go to print. In fact, many years ago, again going back to classified. I may have told you this, but there was Daniel Ellsberg. I think right now Netflix is running the story on the Post, referring to the Washington Post, and that was about the release of what has been come to be known as the Pentagon Papers. And the Pentagon Papers were a series of reports, classified reports, not intended for public consumption, about many of the U.S. military actions and things like that over the years. And among other things, it revealed that some of the things that the government said during the Vietnam War were not true. Um, and so the Pentagon Papers, and it wasn't just that war, there were other conflicts as well that it reported on. That this Daniel Ellsberg worked for a nonprofit organization that had done the analysis. So he had seen this analysis and felt like it was appropriate that the public know what this analysis said about how we'd gotten into wars and sometimes lied about things and stuff like that. Well, Daniel Ellsberg did go to prison. Now, that's something I disagree with, but I think there should be a change in the law about that. But he went to prison because he did reveal classified information. He did break that law. But both the Washington Post and the New York Times ended up printing the Pentagon Papers. And while the government threatened them, in fact, they tried to stop them from printing them at all. And it went immediately to the Supreme Court, and the Supreme Court said, you can try prosecuting them afterwards, but you can't stop them from printing it. And so the Pentagon Papers were printed, despite the government's opposition to it, despite the fact that it was considered classified information. And the government decided not to try to prosecute them afterwards. By then, it was too late anyway, so it would just make the matter worse by prosecuting. So the Post, and that has actually never been settled. Could they have been prosecuted successfully? I think it would have been a difficult try, and I think that's what the government knew, because in a criminal case in America, all the jurors have to agree that the person's guilty. I don't know on what basis they were able to get Daniel Ellsberg into prison. I would have thought one of the jurors would have said what he did was a good thing. And maybe they were restricted in what his lawyers may have been restricted in what they could say. I'm not sure. But anyway, he went to prison. The papers were not prosecuted. So there are, again, this is outside of this PowerPoint and outside of what most textbooks cover. There are legal issues beyond these that we'll talk about today as far as libel and invasion of privacy and so forth. So anyway, going to these areas, John T. Delane, editor of the Times, said the press lives by disclosures. And so by that very nature, you live a little bit on the edge, cutting edge, so to speak, and are in danger sometimes of crossing that line and getting into legal problems. If errors occur, they are public and may subject the error maker to liability. Again, not mixing up liability with libel, totally different words, spelled totally different. But nonetheless, liability could be a lawsuit. It could, in some cases, be more serious. It could be criminal, and there's certain, like say, if it's classified information or something. But mostly, it's a lawsuit liability. So misunderstanding the law or careless in reporting can be dangerous. So as we said, libel is unjustified damage to a person's reputation caused by bringing that person in hatred, contempt, ridicule in the eyes of a substantial or respectable group. A story is defamatory when it wrongly accuses a living person of a crime or immorality. Now, if I put a couple of words in there because I think I borrowed this PowerPoint from somebody else, and I think it's important to I put in the word unjustified and I put in the word wrongly. If somebody already has a bad reputation, if they are a criminal, then you can't libel them. They're already a criminal. They already have a bad reputation. So it's almost impossible to libel a crook. It's really hard. And ultimately, one of the defenses against libel is truth, is whether it's true. That is not a defense, by the way, for invasion of privacy. So as we talk about the difference between libel and invasion of privacy, you can tell the truth with invasion of privacy and get sued for $100 million or whatever. So there is a distinction between those two and the value of truth in defending yourself. So obviously an editor and the journalists, the writers themselves, have a responsibility of making sure they're accurate, that they're exact, and that they're using good judgment, or they put themselves and their media, their newspaper, their TV station, whatever, in jeopardy. Now this suggests that I also added here, in America, even if libel occurs, it should not frighten the staff if it understands protections, potential consequences, and appropriate responses. But that's in America. Again, in other countries, and many other countries, if it's a crime, then lots of luck. You're going to end up in prison. So when in America, it is, the worst thing that can happen is they sue you and you owe them a certain amount of money. But most people who would file a lawsuit will actually give you a chance to back your way out of it by printing a retraction and by admitting that you're wrong and doing it in a prominent enough place that they feel like you've made up for your wrongs, or at least that if you haven't totally made up for it, that it's not worth taking you to court now. And if you go to court, the fact that you did print a retraction will be a mitigating circumstance on how much you have to pay the person that you libeled. And so it's typically not a matter to freak out about, but if you're careful, if you're doing your work the best you can, it's not very often you'd find yourself in a libel suit. Again, in other countries, the government itself. In fact, I guess the other thing I would say about America and I'd say Western democracies and many other countries is that in America, one of the hardest people to libel are the most famous people. They are considered to be seeking publicity and for your comments to be pretty much fair commentary in most cases. Now, there are cases right now, for example, that some people are going to take some of the media to court, and I'll explain on what basis they're going to go to court. But it's, in fact, probably 25 years ago, something like that, it was seen as pretty much impossible for a famous person like a president or a senator or somebody or an actress or actor to win anything in a libel suit, and probably an invasion of privacy, either one of those, because they're so seeking so much publicity and everything that they're just, the courts pretty much laugh them out of the courtroom. But there are distinctions to that. Anyway, what I was saying, those in other countries, it is definitely used as a weapon against journalists by the government, and the most powerful people use it against journalists. Whereas in America, those powerful people don't have much power when it comes to libel and invasion of privacy. It takes a really strong case for them to win anything. Points out here in America that only the person who is libeled can file a lawsuit, so their relatives can't, friends can't, only that person that was libeled. There is a period of time in which you have to file the suit if you're going to. Now, a person who has been libeled can ask for a print, for the medium to print a correction, and the media should respond very quickly to that. If they, unless they're saying there was no mistake and they're willing to stand by that, they should reprint the retraction very quickly. Let me say, when I went back about talking about that little German guy backing me into the corner, I have to admit something. I was really stupid. I had no need to print a retraction. But what I should have done was offer to print his side of the story and let him answer the questions in another story. I mean, it would have been a good story. But by then I was angry at him. He was clearly angry at me. I could have turned that into a much more positive situation if I had simply said, well, that's water in the bridge, forget about it. Let's sit down and you tell me your story and we'll put it in the front page. I mean, this is an important story to us, our community. It's very interesting to find out your angle on it. So I think it's a front page story. So have a seat and we'll print another story. That's fine. And I think probably instead he ended up causing me lots of problems in the future, after that. Whereas it would have been much better to have him be a friend than an enemy. And there was really no reason. Well, I mean, I don't know. He might have still been mad. I don't know. But it was really stupid of me not to offer to run us another story, because it would have been a good story anyway. I was just stupid professionally to do that. I had done that once before, and maybe it was easier. A friend, she was the head of the school board that ran all the schools in the area, and she decided to resign. And anyway, so I interviewed her, and I wrote all the reasons why she was going to resign. It was an unpaid position, and she was talking about how people would always be upset with her. Anyway, she was just complaining about how ungrateful people were, and how they mess up her life. So she just wanted to get out of there. And so I published the story, and it was, I know I was accurate. I think in that case, I don't think I actually recorded that one, but she was a friend of the family. So I did not want, in that case, I very readily said, well, look at, if you think I misrepresented what you said, then you write it yourself. Send me write a letter and I will publish it. Well, then she sent me a letter and it said exactly what I said. I don't know what she thought was different. What she said in her letter was exactly what I said in the story. And I published it verbatim. And there were still people that said that we had made up the letter. It was crazy. So anyway, you can't always solve a problem that way. But if somebody complains, think how you can deal with them in a way that will help calm them down. And he might, in this case, the bank president might not have tried to get me in legal trouble if I had just bothered to say, have a seat, we'll talk this over, and tell me your story, and we'll publish it, and that would have solved the problem. So you need to be careful not to get your back up in those situations, like I did. So anyway, it would be wise for a publication or a TV station to try to stop something like this from going to court. In this case, it also mentions sometimes they offer a nominal payment to keep them happy if they think that, I mean, once you go to court, especially in America, it's going to cost you a bunch of money regardless. In fact, I'll show you a situation where the court ended up finding a newspaper for $10,000, or the jury recommended a $10,000 fine of the newspaper, something they should not have had to pay a cent on it, and they ultimately agreed to do it. Which actually they shouldn't have even gone to court if they're willing to do that, because then they had what they did was totally legal. Absolutely could have been won on appeal, but they didn't want to spend more money on their lawyers to appeal it. So instead, they allowed a lower court decision to stand. They should have just made sure they didn't get into that lower court decision. But I'm sure they were thinking, if we pay one person, somebody else is going to want us to pay them. Anyway, it's a difficult situation to know what to do. If somebody could be paid off for $10,000, then for most newspapers that would probably be cheap, because by the time you get a lawyer and stuff, it's going to cost you more than that. But again, it depends how big a paper you are and stuff. In America, the First and 14th Amendments to the Constitution protect the right to free press, and as well as the right to civil liberties, so that if somebody's trying to stop you from exerting your freedom of the press, free speech, free press, that should kind of a double backing by the Constitution. There is, however, it says since 1974, it was decided that the U.S. Constitution does not require private persons involved in public issues to prove actual malice. Now let's go to what it means by actual malice. Malice, you may not be familiar with that word, means basically that you hate somebody. It's kind of like prejudice, I guess you could say, that you feel hate towards someone, therefore you feel malice towards them. Originally, and still for public people, actual malice is still a requirement for them to win a libel suit. Or if somebody's famous who's looking for publicity and stuff, so the definition of actual malice is either knowledge that what they said is false, or that they had a totally reckless disregard for truth. In other words, in parentheses here it says they had reason to doubt what they printed was true, and they made no effort to verify it. And so it's on that basis that right now a senator is suing CNN, I think it is, because what they said about him, they felt he fell into this area of being reckless disregard for truth. That if they didn't know it was false, they at least had reason to doubt it, and they made absolutely no effort to verify it. And so we'll see how that goes. It's, like I said, it's considered very difficult for a public person like a U.S. senator to win a case like this, but he thinks that they had actual malice. With a person who's a private person, not a public person, they don't have to go that far. If it's false, it's false. If you have hurt their reputation, then it's not actual malice. It is they can take you to court, even if you just made a mistake. Let me put it that way. You just made a mistake, you can still go to court and be sued by a private person, not a public person, but a private person that you have libeled. In most cases, Libel, the defense for libel is truth. Um, it says here an absolute defense. It's, well, let me put it this way. It depends a little bit. Of course, first off, you have to, it depends on the jury. So you have to be able to convince the jury that it is truth. But also, again, it overlaps pretty easily sometimes with invasion of privacy. So you could say say something bad about somebody, and it's true, but was there any reason for you to put that in the newspaper or put it on TV? If there was no good reason for it, and this was somebody who did not seek publicity, this is a totally private person that just wants to be left alone, then they might not get you on libel, but they can get you invasion of privacy. So the two can run very close together sometimes. So a publisher or a station owner needs to keep keep documents and witnesses, be aware of who can go to court for them if they need it. There are ways to, and I guess I'll insert as one of my stories here. Sometimes it can, if you know that you have somebody that you're reporting to somebody who is just, you think is of the nature that they would like to take you to court, even if what you say is true, that they will, in order to protect themselves, like a big business or something like that, then you need to take some precautions. Even if they are somebody that's very public. For example, I think I told you about Jack Anderson. Did I tell you who Jack Anderson was? He was a person who was the most famous investigative reporter in America for about 20 years. He wrote an investigative story every day. When I went to a conference that featured investigative reporting, and they had a number of Pulitzer Prize winning investigative reporters in a panel. And somebody asked the question, how do you compare what you do to Jack Anderson? And everybody in the panel who had won the Pulitzer Prize, again, the very top prize of journalism in America, everyone said, what we do doesn't compare at all to what Jack Anderson does. Because they would win a Pulitzer Prize for one story that they may have worked a year on. And whereas Jack Anderson was printing an investigative story every day, in fact, sometimes more than once a day. He had 900 newspapers were printing his daily column, and for a while he was on TV at the same time, reporting a different story on TV. One of my friends was his top reporter, so they would co-byline together, and one of my other friends was his editor, and so I got to know the operation pretty well. And anyway, my friend that was his top reporter that worked with him was telling me about one of the incidences and I can't remember what it was, but it was an investigation of a public official. So in this case, a public official is very powerful. You have to be very careful in dealing with public officials. And so what he told me, was that they got all this information. They took the information. By the way, this may sound very similar because in essence, this is what happened in the Trump investigation, is that people got a whole bunch of information together, and even though it wasn't proven, they took the information to the FBI, and the FBI said they would look into it. And so in the case of Jack Anderson and my friend Del Vanata, their story read, the FBI is investigating such and such a public official to see if he did such and such bad. I don't remember what it was that he did bad. And so by the fact that the FBI was investigating, that protected them from a lawsuit themselves, because they weren't making the claim directly. They gave their information to the FBI, and the FBI was investigating it. So now they knew what the FBI had because they gave it to them. So they could go ahead and report the evidence they had because they gave it to the FBI. But they could still say it was the FBI investigating it, and they didn't have to take the blame themselves, so to speak. And in essence, that's what they did to Trump, by the way. The Steele dossier was a whole bunch of junk, and ended up that none of it was provable, and a lot of it was proven not true, and the rest was never proven as true. Um, and But they were able to get it. They're still trying to get him impeached on some of the stuff related to the Steele dossier. Now, today there was a new report that came out and verified what the Republicans have been saying about there being a lot of bad law work, illegal law work, even in that investigation, and that's going to be followed up on later. But anyway, so when I was the editor of a newspaper, I decided to do the same thing. I remembered what my friend Del Van Nat had done. In this case, I had read about a newspaper or the police, I think it was, someplace had done a sting operation on the liquor stores. Now, in some states, liquor stores are actually owned by the government. In other states, they're licensed by the government. But every state has some sort of rule where you can't sell to minors. And the definition of what a minor is varies. But it's against the law. And in the state I think I was in, Arkansas, I believe the age was 18. You couldn't sell to anybody that was younger than 18. Anyway, so I had read from some other place that that police had done a sting operation, sent in a young person, and that a whole bunch of liquor stores had sold liquor to the teenager, and they were prosecuted. So I decided we could do that as a newspaper. So we found a teenager willing to work with us, and I sent her out with a reporter, and she went in and successfully bought alcoholic beverages from 8 out of 8 liquor stores. And she just brought the liquor back out, the alcohol back out to our reporter, who labeled it, and then they went to the next store and so forth. So then we went to the police station and said, "Here's the evidence. This is what we've done. The teenager went in, bought all this. There was no consumption. We have all the alcohol here for you. You can have it if you want it, but this is the evidence." And it went to 8 out of 8 liquor stores. They all sold. Some of them looked at her ID to check her age, but either they don't know good math or they didn't care, because they still sold it to her even after looking at her driver's license. So what did happen was exactly that, by the way, that the Liquor Association, that's some sort of association of all the liquor distributors, and they did take us to court. Luckily, at the time I did it, I was the editor of a newspaper that was part of a chain, and the chain stood up to them, but it took like a whole year before the judge threw it out. He should have thrown it out first day, I think. I don't think there was any basis in which not to throw that case out, because obviously it was true. On what basis they had to file the lawsuit is really, to me, was still so flimsy the judge could have thrown it out day one, but it took a whole year before it got thrown out. And so, there are different tricks that you can do. In this case, getting the FBI or the police or somebody involved in something, but I was correct in taking that precaution. If we had not turned over the alcoholic beverages to the police and brought them into the case immediately, we might have lost that case. We might have been sued for millions of dollars. So anyway, there are ways to play the game, so to speak. Now, there is also a liable defense of what's called privilege. Privilege means in America that there's, in this case, it's talking about judicial, legislative, and executive proceedings, that you can report on those, even if there might be libel in those. So let's say you go to Congress, and one member of Congress starts accusing a member of Congress about sleeping with his aide or something that would be libelous to put into the paper or on TV. Well, if it took place during an official proceeding, you're okay. That's considered privilege. It took place in a public um, a legislative sort of meeting, or if it had taken place in a courtroom, something like that, you're protected to report that. But you do have to be careful because you need to be accurate, you need to be fair, um, and you need to be careful to understand that a statement by an attorney outside the courtroom, for example, is not privileged. So if you're in the courtroom and then you walk outside and the attorney starts talking to you about something and he tells you something that would be libelous, that's not protected. That's no longer in the public proceeding. So you're not protected. You need to be careful about understanding what is going to be protected and what's not protected. A press release from a government bureau is not protected. So even though it's a government document, it's produced by a public agency. Now that would be hard, I think, for somebody to take you to court on if it's accurately quoted from a public press release from a government bureau. But technically, you're not protected by privilege. Let me put it that way. You'd have to defend it on some other basis, not privilege. The other bullet item in my secret study, when I was working for the daily newspaper, I was thinking about these issues, and as I was editing some of our pages, one of the things we would be printing would be, there were government records, but they basically were things like, I think I maybe told you this before, that Ken Harvey was released on bail on the charge of burglary or whatever. Well, we weren't putting in, or the government document did not provide us other identification material. And so the question was, are we committing libel? Could we be sued for printing this public document that itself is slandering me in this example, when it was some other Ken Harvey, or whatever the name is, fill in the blank. And so I got permission to contact all the daily newspapers in our region and ask them that question. Do you feel safe printing these public records that are libeling people without getting additional information like their address, like their age? So that's when we were talking about identification earlier, ID. That's what I meant by it, and you guys were confused by my use of that word. Well, that's the additional ID that would protect you. If you give the address of somebody and his age or something like that, then they would know it wasn't this Ken Harvey, it's some other Ken Harvey. And so that would be protecting yourself. But these records we were running on a regular basis did not have that information. And so that was the question. And most of the editors that I surveyed agreed that they felt like they might be in jeopardy. But I had to agree, before I even started the survey, I had to agree I was not going to publish that very good research. Because obviously if we let everybody know that they thought they might be sued, they would be sued. And even more so by the fact that they admitted that they thought they could be sued. Then that gives a person even more, they're able to say then that's actual malice. You not only libeled me, but you knew there was a good chance that there was somebody out there by this name that was going to be libeled, and you didn't care. You didn't bother to go find out an address. So that's, and then it's not only libel, it shows actual malice, that even a public official might be able to sue them. Fair comment. Fair comment particularly relates to things like criticizing a movie or criticizing a restaurant. If you have a blog or something where you evaluate how good restaurants are or something, at least in America, you can make fair comment. You have to make sure, though, you don't have any false information in there. Your opinion is fine. They have terrible food. But if you were to say something like, rats are running around their kitchen, and that's not true, now you've gone too far. So you may need to make sure under fair comment defense that that you're not printing anything that is provably false in that fair comment. Your opinion can't be proven false. Your opinion's your opinion. But rats running around the kitchen, that's something else. And that would certainly be true, a fair comment would certainly be true for public officials or people running for public office or anything like that. Again, can you go too far? Yeah, you could go too far. And they could, that would be if they're running for public office, particularly something like that, then you go back to actual malice. Was it a reckless disregard for truth that you printed this about somebody? And they might go after you for that if it's provably not true, and they can show that there's reason that you would have had reason to check on it and you didn't do it. Again, we talked about making corrections. Especially if you're obviously if you're at fault. If you're not at fault, then you decide whether it's worth making a correction when it's not a correction. You don't really believe it is a correction. But it will if you've run a correction, and even if they take you to court and sue you for libel or invasion of privacy, particularly libel, that'd be the invasion of privacy is what really wouldn't be under this category. But if you've libeled them and you correct it in a fairly prominent way, then if nothing else, it should reduce the penalty. You might still have to pay some money for libeling somebody, but it should be less than if you didn't correct it, for sure. And in some cases, if you print the correction, the people will just drop the suit. That's all they wanted. They wanted you to confess that you were wrong. That's all they want. A right to privacy is, like I said, is kind of the sister of libel. In the case of right to privacy, you're revealing information that you have no right to reveal. Again, this is really hard to do with public people. But I think there was a case that was won by an actress because she was on a private beach, I think with her husband, and she was swimming topless. And somebody took a picture of that and ran it. And so the case was, I may be a public person. You don't have the right to publish me, half naked when I thought I was being discreet. I thought I was someplace where I was not going to be seen by anybody. And you're sitting up in a hill with a long lens, the paparazzi, and revealing parts of my body I didn't want to reveal. Thank you very much. And I think she did win quite a bit of money for that. I'm trying to remember. I have to go back and look. This was a number of years ago. This was probably I think it's probably 20 years ago. But it's somebody I think that is still famous, but I would have to go back and think and find the name. But anyway, it was you can be sued for invasion of privacy even with somebody who seeks publicity if you go too far. There's a kind of a question. You can't really invade their privacy, if they're in a public restaurant and you take their picture there. I mean, that's that'd be laughed out of court. But if they're on a private beach swimming nude or whatever, then that's another thing. You've gone too far with that. So basically, the presumption is under right to privacy is that intrusion, that you've made an intrusion on a plaintiff's private affairs, public disclosure of embarrassing private facts, publicity that places the plaintiff in a false light in the public's eye, whatever, that's inappropriate. And if it's a private person particularly, then it's none of your business, or if you go too far with a public person, as in the case of the movie star. Now, it does not cover if it's legitimate public interest, and I'll show you, I'll come back to that when I'm done with the PowerPoint. There's in fact, related to something I was just talking about, the newspaper that ended up paying $10,000 to somebody. I'll tell you the story, and then I'll show you the picture. The story was the lady was being held hostage by her ex-husband or ex-boyfriend, and he had made her strip naked so that she wouldn't run away. And then ultimately, the house was surrounded by the police, and the guy killed himself. And she came running out with a very small towel that did cover her breast and barely below the crotch, but it was a very small towel. You could see the side of her hip, and among other things, you could see that she had on the side of her hip that she had been wearing a bikini. So she wasn't somebody that was afraid to wear a bikini. But you just see the side of her hip. Anyway, she sued and won $10,000 on that. And so the issue is here, which took priority, the right to her privacy or the fact that this was an actual real news story of public interest? Now, I believe that the newspaper would have won that on appeal if they had bothered to, if they thought, yeah, it's worth us fighting this $10,000 fine to make sure that nobody else takes us to court on something that's similarly absurd from their perspective. But I think they just paid the money because they just, like I said, they'd end up spending a lot more money than that to go to appeal it. So $10,000 is worth their while just to pay it. Although it set a bad precedent, because I'm 100% sure that a higher court would have thrown that out, because it was something of public interest, and they actually didn't show anything private. I mean, they didn't show her breast, they didn't show her crotch area. They showed the side of her hip with a bikini strip on it. That's all that you could actually see, but she was very upset, very emotional, and I mean, you could tell she was naked, but you couldn't see anything private. So there was just no basis for that lawsuit from my perspective. 100% chance of being overturned. But I'll show you the picture when we're done with this. There are some other things that you need to understand about the law, and for example, different countries, different states protect juveniles, that is minors, from publicity, even if they're guilty of something. It still protects them. So a kid could be guilty of shoplifting, and they'll still protect his identity in some states, in some countries, in some states. So you need to be aware of how they treat juveniles wherever it is that you're working. Sometimes it may be allowed if they're in a public hearing, if they're in court, if the judge gives you permission. In some traffic cases are not considered so serious, excuse me, that they're going to say you can't. If they committed a traffic crime, that might be okay because it's not that serious, and it might actually keep them from doing it in the future if they're embarrassed for being reported for committing a traffic crime, something like that. So, but anyway, you need to be aware of how juveniles are treated under the law of your state or your country. Some are protected. And by the way, it says here that by their definition, a juvenile is under 17 and a minor, it depends on when you can drink, basically. And so I remember that now, but it's something that I had forgotten, that, yeah, juveniles are considered legally in America as being under 17, whereas minors, I always kind of consider them to be the same thing. That minors are those that are basically of legal age to drink, basically. And that, by the way, that might come up with something like, you may be aware that there's something in America called statutory rape. And statutory rape is for an older person to have sex with a younger person, even if it's with their permission. In essence, what it considers that they're not old enough to give their permission. So if a 25-year-old has sex with a 16-year-old juvenile, that's considered statutory rape, even if it's with her permission. Now, how the courts will handle it as far as what kind of if there's clear evidence that the juvenile wanted it, and that they might go pretty light. But the parents, again, the parents have some recourse there, so that doesn't necessarily keep somebody out of jail. In fact, probably won't keep them out of jail. It just may mitigate how long they're in jail. Copyright and plagiarism. You need to understand that stories can be copyrighted, but news can't be. And so it is possible. For example, I explained that one of the things when I first got out of college and became editor of that 120,000 circulation paper in Tampa, Florida, one of the things I did, because we didn't have a very big staff, was I would take stories from the daily newspaper and I would rewrite them because they don't have a copyright on the news, they have a copyright on their story. And so I can take the news and then I would call their main source and ask their source, is what the Tribune put in their paper accurate? And if there's any question, follow that up. And if they said it's accurate, then every fact in there is now open for me to use because the source agreed that it was accurate. And basically it's the same as if they told me all this stuff directly. And then I'd ask additional questions to make my story better than the original story. So that's where I mentioned I'd start asking how and why questions that very frequently in like a fire story, something like that, the reporters would not ask the why and how questions, or perhaps they wouldn't even be available, that information wouldn't be available yet, but it's such a small story, they never bothered to follow it up. But I followed it up. And there was still something interesting in that story that they didn't, even though they wrote the first day story, now on the second day, they didn't follow it up, but I did. And it turned out good. There is, besides this, though, as I noted here, a question of unfair trade practices. So in the early days, if I remember the story right, and if not, it's not far off anyway, AP was when they would, Associated Press, again, is a wire service that sends out stories to their members' newspapers. And so AP was, in those days, teletyping it out to the newspapers. And just to get publicity, the newspapers would take the teletype version and they would put it up on a bulletin board outside their newspaper. And so that people could read the news as it came off the press, or as it came out of the teletype. And so they got a lot of people coming around their newspaper just to read the big bulletin board of the latest news that was coming before it could be printed. But among those coming to read the AP stories off the bulletin board were reporters for the United Press International, a competing wire service. And they were coming and taking down all that information, going back and sending it out under their name. Now, that wasn't infringement of copyright. What they found that was to be an unfair trade practice. They were basically stealing somebody else's material, doing their hard work and sending out as their own. And the courts did decide that was not fair as a trade practice. It was not infringement of copyright because they wrote it in their own words, but it was just taking advantage of their reporting and claiming it as their own reporting. And so and they were doing it routinely enough. It wasn't like one story. It was every day they were doing it. And so the court stopped them from doing that, and I think they had to pay some fine for it. Again, I talked in America, the FCC is the Federal Communications Commission, and that is the body that was, I think its name was changed, but that's the body that was given power in the 1920s to license broadcast channels and given some regulatory, like regulating indecency, which has changed over the years, what you can say, what you can do on TV. You can do and say much more now than you could in the 1960s when I was a kid. Around in the 1970s, suddenly they were able to put more stations over the airwaves by new technology. And so in the 1980s, under Ronald Reagan, they took away a lot of the rules that were handicapping the broadcast, radio and TV. And so there was, for example, there was one rule that the FCC had created was called the Fairness Doctrine. And again, because using the rationale that not everybody could own a TV station, they felt entitled to regulate the TV stations or the radio stations that existed. And so the Fairness Doctrine said, if you cover Donald Trump, you have to also cover Joe Biden, sort of thing. Or if you cover this issue, one side of an issue, you have to cover the other side of the issue. If you have a story or whatever, some discussion on how, let's say, abortion is bad, you have to invite people on to give the story of why abortion is okay, whatever. So, but the Fairness Doctrine made it very difficult to have any public discussion at all, because it put so much. Well, it was very difficult for radio and TV stations to do this on a regular basis and make sure they were not violating that law and have any public discussion at all. Consequently, there just was not very much public discussion on TV or radio. So once they started opening up new frequencies, because they could fit more into the spectrum, under Reagan, the FCC agreed to do away with the Fairness Doctrine. Now, the equal opportunity or equal time, that's like for paid advertising and stuff. That they're still, if they sell advertising to one political candidate, for example, they have to sell it to the other political candidate at the same price, that sort of thing. But the Fairness Doctrine was the one that when they threw that out, then it was interesting. If one of the big examples of, to me, perhaps the best example of the uses and gratifications theory, as you guys proceed and start looking at doing your own theses and stuff. And one of those theories is the uses and gratifications theory, that people use media, that media doesn't just use them, but they use media for their own purposes. One of the biggest examples of that to me was what happened after the Fairness Doctrine was thrown out. Because suddenly, and it's also one of the biggest evidences that American media is controlled by liberals. The evidence is that as soon as that Fairness Doctrine was thrown out, talk radio took over the radio stations. That became the biggest thing, was talk radio. And 90% of the successful talk radio, probably more than 90% of the successful talk radio hosts were conservative. And they were successful because conservatives did not feel like any of the other media was representing them. That the newspapers and the TV stations and the national news and so forth was all reflecting liberal biases, and that they were ignoring the conservative perspective. And so once the Fairness Doctrine was thrown out, liberals tried to start talk radio, but most of them went broke because they had no audience. Liberals did not have the need or feel the need for gratification or feel the need for having talk radio talk about liberal perspective, because they already felt satisfied with the other media that was already reflecting their perspectives, would be my conclusion, because it never worked. Like I said, I think the successful liberal talk show host was no more than 5%, maybe 10% at the most. Almost all the success was with conservative, and the successful talk show hosts like Rush Limbaugh made millions of dollars off of it. They were really, really successful. And I think that's what led to Fox TV. It was pretty obvious that once all these guys were making millions of dollars off of talk radio, it didn't take a genius to say, gee, I wonder what would happen if we did that on TV. And so Fox now has the most popular, not just their news and their commentary, their discussions and stuff, are the most famous among all the national networks in America, um, but probably not equal to all of them put together, however. So it's still 18-2 as far as the liberal media versus the conservative media. It's still 18-2, but those two are very successful. Particularly Fox TV is very successful because of needs and gratification. Because the conservatives flock to Fox because they don't have their needs um, satisfied by the other media, and so they go to Fox. In the old days, and in some other countries, I lived in Central America a couple of years, and they love to put big crime stories and accidents where people died and stuff on their front page. So you saw car accidents and stuff all the time on the front, big pictures of the car accident where people were killed and stuff. And that was the way it was in America earlier. That sort of stuff really got a lot of readers, but not so much anymore. That stuff is played down mostly in America press. Um, that doesn't mean it's not important to cover, and some suggest that it might even ought to be covered more than it is now in American press. But it used to be the highlight of the newspaper, and it still is in some countries where you want to put the most, the biggest fire, the biggest crash, the biggest crime, whatever, on your front page to get people's attention. Not so much in America anymore. That's not considered appropriate use of space by journalists in America anymore. There's a bunch of in this PowerPoint. I don't know that I want to go through it all, but a lot of people misuse words related to court actions and police action and so forth. Being arrested is better than apprehended or taken into custody, more precise. The arraignment is where they decide whether they're not deciding somebody's guilty, they're deciding whether to proceed, that they can hold them in jail anyway until they have a chance to decide what to do. Preliminary hearing would be where somebody will be able to present their evidence to get out of jail and to maybe even have the case thrown out if they have good enough evidence that the judge might decide that there is no case and just release them, period. On the other hand, if in the arraignment and later in the preliminary hearing, if they decide that there is adequate reason to keep them in jail, in America they allow bail. And a bail is basically you don't necessarily have to put up the money cash, but you have to put up something worth money. For example, if you own a house and the equity in the house is $100,000, and they say your bail is $100,000, well then you can go in and sign some paperwork where they get your house if you run off. And so they'll let you out of jail because you'll lose your house, and they of course have to go hunt you down again. There's also people called bail bondsmen, and a bail bondsman is somebody who maybe you pay him $10,000 and he promises to cover $100,000 to the court if you run off. If you do run off, they send somebody after you because they're going to lose $90,000 if they don't. And so that they'll hire somebody to go after you if you run out and don't show up at court like you're supposed to. But overall, they make money off the deal. They take several thousands of dollars and then guarantee the rest for you, so you don't have to come up with the whole whatever it is, $100,000, whatever. There's two words here. I guess it's kind of buried here. Parole and probation are two words that people should understand in English news writing. They may have different words in different countries, though. I don't know. But very frequently, a prisoner is released on parole from prison. And they sometimes say they're released on good behavior or something like that. That he's been good enough. He's been a good enough prisoner that he wasn't causing any trouble in prison, therefore they let him out a little bit early on parole. If he does anything wrong, there's usually stipulations for parole, like he can't be seen with other criminals, he can't carry a gun, he can't, a lot of restrictions what he can't do, and he has to show up and talk to his parole officer once in a while to explain that he's got a job, that everything's going fine, whatever he asks. Probation is something else. Probation is, let's say you're really young or something and you commit a crime and it's not seen as part of your nature, and the judge, gives you a good yelling and he says, basically, you're out on probation. I sentence you to 5 years, but on probation. So if you don't do anything else wrong, you can go home. The day you do something wrong, you owe us 5 years. And so it's not, you're still assigned a certain amount of debt to society. If you do anything wrong ever, you could be thrown into prison in a trial because you've already been found guilty and been sentenced to 5 years. And so if you do something wrong, it's to jail immediately. And then you might be also tried on whatever you did wrong the second time as a second offense. But you go to jail because you broke probation. They also would have probation officers so they can keep track of what you're doing, that you aren't doing stuff bad. So again, just like parole, you might have to go see a probation officer, same as a parole officer. If you have gone to prison and been let out early, it's a parole. If you didn't go to prison, it's probation. So they're very similar. In both cases, you report to somebody what you're doing, and you're staying out of trouble, so forth. It says here that the word alleged is a trap, used in reference to a specific person. Jones, the alleged gambler, offers little or no immunity from libel. So you need to be real careful about thinking that you're protected by that. Jones may be charged with gambling or indicted for gambling. In both instances, alleged is redundant. So be more specific if he has been charged, or in the case I was saying, if somebody's being investigated, that's fair because the police or the FBI is investigating somebody. That's what you're reporting. But if you use the word alleged and that's because Joe Schmo said he's really a crook, and you say, well, the alleged crook. Well, if it hasn't gone through any legal process, then you better not think you're safe by using the word alleged. So listing wrong name in a crime story is the surest route to libel action. Well, this goes over with what I was talking about with my study. I mean, it was maybe the right name, but you didn't give any other identification. So there are more than one Ken Harveys in the community, and you just said Ken Harvey committed a crime. So you need to, in the case I was talking about, those were in public records, so maybe the press could be protected by that, but they didn't know. The editors were not sure they would be protected. But if it's in a news story, and you don't bother to get the rest of the idea, get the address, get the age, get other identifying information so people know which Ken Harvey this is, then you're totally opened up to a lawsuit on that. That's an easy case. And it could also be, it doesn't say it here, but it could also be the wrong crime. It could be the right person, but the wrong crime. If the crime you say he was being charged with is the wrong crime and it's more serious than one, then you say he was charged with a more serious crime than what he really was charged with, that could be libelous. So you need to be careful about that. So the wrong name, the wrong crime, those facts become very important to protect yourself from libel. There's two terms in America used when somebody is sentenced to prison: consecutive and concurrent. are important terms. If a man is sentenced to 2 consecutive 3-year terms, he faces 6 years in prison. If his sentences are concurrent, then he only faces 3 years in prison. In other words, so he's given a 3-year sentence for 2 different crimes. It's a major difference whether it's concurrent or consecutive. So again, consecutive, one after the other, concurrent at the same time. There's 2 types of juries in America. One's the grand jury. Right now, the people investigating the investigators in the Trump scandal, the people investigating how, Trump was never found, that they didn't find enough evidence to say that he was guilty of anything. And so right now, the Attorney General and U.S. Attorney are investigating on what basis did they start doing this investigation and so forth. Was it for a purpose, an illegal purpose, or was it legal? Legal or illegal? Well, one of the words they use today in the first report by the Investigative General of the Justice Department was that there were serious mistakes made and at least one crime committed, but he did not find enough evidence to say that there was political bias in how they handled the case within the FBI. However, immediately the U.S. Attorney and the Attorney General both said, "Not so quick. We have more stuff to come, and we know more than the IG knows." So this whole thing is, and one thing the IG did not have the capability of doing is call a grand jury. The grand jury, they have, I think, already called a grand jury in the investigation by the U.S. Attorney. And what they do is they present their evidence to a grand jury to see how they respond to it. And so, in other words, they can return an indictment and say, the grand jury can say, we think you should prosecute this guy for doing this stuff. And so the grand jury does not rule guilty or innocent, but they do rule, yeah, you should go ahead and have a formal trial. So there's 2 different types of juries. The grand jury is investigative in nature, and then there's just the trial jury, which is to decide guilt or innocence. There's some Latin terms. I don't know. I guess I'll cover them. The corpus delicti refers to evidence necessary to establish that a crime has been committed. In other words, actually, that again could be included in the current discussion on whether Trump bribed or was trying to get the Ukrainian president to do what he wanted him to do, to investigate his enemies, is what the Democrats are saying. Well, the corpus delicti is there really evidence that he did that? The Republicans are saying there's not an ounce of evidence. There's accusations, there's outrage, there's lots of things, but there is no evidence that he actually did this. The nolo contendere is when somebody accepts a legal verdict, but they don't admit guilt. So basically what they're saying is, and this was done by a vice president in America. He resigned from office, and his plea in court was nolo contendere, that he did not think he could win the case, but he was not pleading guilty. So he basically said, do it with me as you want, but I don't plead guilty. I'm not going to fight it, though. I'm not going to fight the charges, but I'm not pleading guilty. A couple of other misused terms. Would-be robber. There's no such thing as would-be robber anymore. There's a would-be ball player. That there's once a person tries to commit a robbery, then he's a robber. It doesn't matter whether they got any money. By definition, the robbery, that goes down to some of these other terms. To steal and to rob are 2 different things, or to commit a theft. Steal is kind of generic, but theft means that you did not have to threaten somebody. In other words, and that would be the same with burglary. Burglary, you break into somebody's house and you steal stuff, but you didn't threaten anybody. Robbery requires that you're holding a gun or something, a knife on somebody and saying, give me your money. That's a robbery. So you're forcing the situation, whereas a theft would probably be considered the same as burglary. Would basically you've stolen something, but you didn't use force to do it. So they're different, and they need to be treated differently. Um, and it suggests that, stay away from cliches like hit and run, axe murder. Just be specific. Somebody was charged. You hit somebody with an automobile and failed to stop. Is your hit and run? That's the cliche. I don't know. I say that one is quite often used still because it's hard to say. Hit by an automobile and failed to stop. That may be more exact, but most Americans understand what hit and run is too. That's what you mean. Anyway, be specific though. Be careful of legal jargon. This is an example. The case was continued for disposition because the attorney requested no probation report be made on the boy before adjudication. You wouldn't want to write that as a journalist. You want to interpret that in regular English. So you need to understand those terms. What's the guy saying? What was just said here in court? Because I need to try to interpret that to the average American who does not understand what that just said. And yet that may be what you're given in court or by the police. Extradition, accessories. Let me start at the top here. Accessories before the fact or accessories after the fact. In either case, you're helping somebody who's committed a felony, but there's a lot of difference between accessory before the fact. That means you were actually in on the plot. So you might even be committed. It might even be charged with murder in that case. And then accessories after the fact would be that you help somebody escape after they got in trouble legally. Neither one's a good place to be in, but you need to understand what it's talking about. Extradition is shipping a prisoner to another state or to another country because in that other state or in that other country they have jurisdiction. So again, in America, there's 50 states. So if I commit a burglary in one state, I don't have the trial in a different state. I may try to run away from the burglary charge, but ultimately, if I commit the burglary in Washington and they catch me in Florida, then there'll be an extradition procedure so that Florida will send me back to Washington to be tried. And that's even obviously more true when it's between countries. So somebody flees America and they take off to Spain. They have to ask Spain, please send them back for trial. And there are some countries that don't have extradition laws. So some criminals know they can go to a certain country and they, in theory, won't be extradited. They can sit there and thumb their nose at the U.S. government because the government of that country won't ship them back to America. Indicted, again, means accused or charged by a grand jury. It doesn't mean you're guilty. You're charged. Arraigned is brought to court to answer to a criminal charge, guilty or not guilty. And the judge may ask for the evidence from the police. What evidence is there in order to know whether to keep you in jail or not? But other than that, you're mainly from your perspective, you're telling them whether you're going to plead guilty or not guilty. Felony and misdemeanor is a minor crime. Felony is a major crime. Need to be aware of that. Oops. Okay, I think I'm about running out of battery. I'm going to go ahead and close that. We're about out of time. I want to show you a couple of pictures though. Show you what I'm talking about. We are out of time, but let me go real quick to show you these pictures and let you see what some of the issues are when it comes to Um, several items, I guess. Okay, first one here. Is it against the law to run that picture? No. Is it in good taste to run that picture? Oops, I guess you better see the picture. Okay, the guy was trying to climb over this fence and he flipped. Not a real pretty picture, is it? Is that against the law to run that? No. But is it in good taste? They actually, Associated Press did send this out. Some newspapers ran it. Most of them said, this is terrible, take this off. Nobody's going to want to see this. And so, but Associated Press originally sent it out to all their thousands of newspapers. So again, this is a matter of taste. It's not a matter of law, it's a matter of taste. Do you really want to run this picture? Here's one. Let's see if I can blow it up a little bit. Oops. Just moved my picture too far, so I can't. Anyway, so the gal is fleeing in her in her nightgown from a fire. Some people thought this was inappropriate. I would run this one. This one is, it's a fire and she's got clothes on. She's emotional. But I don't, some people protested this picture. I would run it. I think this is news. This one's a harder one. A gunman somebody who was fired by this newspaper came in and shot a bunch of his fellow workers after he was fired. So this is a picture of one of the printers, whatever you call it, that ran their presses, lying dead down by the press. This one is harder. Do you run it? Do you not run it? And this would be hard for the newspaper because this is one of your friends from work, and you may know his family. But it was definitely news. So there's nothing legal about it. The newspaper, I think, did decide to run it. Oddly enough, the newspaper itself decided to run it. They had 500 complaints, and they got a lawsuit too. I'm sure they won the lawsuit. There's nothing illegal about this. But you need to judge, is this something that's worth the hassle of running? I mean, it may be an award-winning photo, actually. You may win a prize with this photo. Is it worth the prize? There's not a pure right and wrong with this, right? You win a prize, you get 500 complaints and have to face court, lawsuit in court that probably was thrown out because there's no legal basis for the lawsuit. It's just, do people want to see this picture? I don't know. That's the editor has to decide. But it's actually the newspaper itself that ran the picture. The newspaper where this happened was the one that I said they ran it. They had 500 complaints. They had a lawsuit. I'm sure they won the lawsuit. But anyway, it's a tough question. Here's the one I was talking about. Okay, so her ex killed himself. She comes running out with the towel. She ends up winning $10,000 for this. Now they actually asked for $7 million. They weren't given $7 million. They were given $10,000. If they'd won the $7 million, then certainly the newspaper would have appealed the decision, because this is not illegal. It's not. This is news. To me, there's 100% chance if you took it to a higher court, it would be thrown out, because this is news. She's embarrassed. I understand that. But it's not showing anything. It's showing that she's very emotional. It's showing that she wears a bikini. What else does it show? It doesn't arise to the invasion of privacy. And I mean, there's a question: if she was wearing no clothes, would it still be legal? And could you still win it in appeals? I don't know. I kind of think maybe she might win if she was wearing no clothes, and they didn't But if they wearing no clothes and they put blocks, over her private parts, I think I think the newspaper would win. And I don't think they would run it. They wouldn't run it if she was totally naked. But this, to me, is an easy case to throw out of court. But since the judge reduced the verdict down to $10,000, the newspaper decided our lawyer will charge us more than that. We'll give her $10,000 and walk off. They would have appealed if it was $7 million, they would definitely have appealed that, and they would have won. I'm absolutely sure. So anyway, those are some that you have to think about. And they're not, like I say, not all these are easy decisions. As an editor or as a journalist, you have to make up your mind. Do we run this? Do I recommend this? This one to me was one of the easiest ones. This one to me is easy. I wouldn't even thought twice about that. This one I would have thought twice about. Not when I was young, I wouldn't have. I don't think I would have when I was young. When I was older, I would. Some of that comes with age. What you think is worth printing. I'm not saying I wouldn't run it. I'd definitely think about it. If I had to say what I think I would do, I think even as an older journalist, I would run it. But it would be a much harder decision. That one, no question on that. This one, I don't know. I might have run it. It's real, yeah. I just went through and went right through his mouth, so it didn't break any arteries. So yeah, I mean it's so weird that I would be tempted to run it. I mean, he wasn't dying. He was just stupid. And so they have a torch here, trying to cut down the fence so they can take his mouth out of the fence post. But this one is, again, I mean, all of these you have to make a decision on. If you're the editor, you have to make a decision on all of these. They're all news photos. Which ones do you run? Which ones don't you run? I'd say this is the least newsworthy, but it's still so weird, I would still be tempted to run it. Just so weird. If he had died, that'd be something else, but he wasn't dying. He was just in pain for being stupid. So I would be tempted to run it. But there'd be complaints. You have to be aware there'd be complaints. And there were complaints on this one, but that one's, like I say, I wouldn't think twice about that one. This one, as an older person, might think twice, but probably would still run it. That one I would probably run. I see no reason not to. And this was a very good news story. I mean, in the sense of valid news. So